If you're still unclear about what you're allowed or not allowed to do under the new Covid-19 Temporary Measures Act, lawyer Justin Chan is here to provide some clarity. Now, he's the senior partner and head of dispute resolution practice at Tito Isaac Co. Hi, Justin. Now, Justin, your firm sets aside 1 hour every Wednesday from 5 to 6 p.m. to answer legal questions from the general public. This to offer support to the community amid this pandemic. What are the top concerns you've received so far?
Well, I think we've received various concerns touching upon, I think, three general areas. I think one is family law, which is quite an interesting area, custody issues, mental capacity act issues, because those cover aged parents, for example, as well as business interruption issues. For example, in employment, retrenchment, if I'm unable to collect on a certain contract, what happens then? Those are the broad issues that we fielded so far.
Well, Justin, you mentioned, business concerns. So in his third budget speech, DPM Heng said firms in all sectors will have 75% of their local employees' wages subsidized for April. Last week, the Manpower Ministry said employers are strongly urged not to resort to retrenchment or prolonged no-pay leave to manage business costs. And in its third annual guidelines released last month, the National Wages Council also said retrenchment should be a last resort. But despite all these, there are those who have been let go from their jobs. So what legal recourse do they have?
Well, everything that has been issued so far on a guideline basis, those are not black letter law. So when you wish to insist on your strict legal rights, you've been retrenched in this day and age, then the recourse would have to be the contract, the employment contract, the primary document. For example, if there was a termination clause, what does the termination clause say? Were you supposed to have been given a notice period? And there are situations where, sadly enough, the COVID-19 situation could have been used as an excuse to terminate a person rather than it being a legitimate reason for termination. So when that happens, we go back to common law principles of unfair, wrongful dismissal and termination remedies.
Just moving away from the workers and an employer bit, the principle of the circuit breaker measures seems to be that people who live in different households shouldn't meet. In other words, stay at your registered address. But what about engaged couples who aren't cohabiting, or married couples waiting for their BTO flats, or even those who live with one set of parents and either the husband or wife hasn't updated the address yet? I mean, there are dozens of other examples, of course, but are these people breaking the law?
Well, again, we have to take guidance from our leaders on this issue because it's not just the black letter of the law, but the spirit of the law. And it appears that the question is not one of family closeness, but it's one of geographical separation. So if you are engaged, but you live in separate premises, then you shouldn't be. I think that is the spirit of the law, and that's what is being advised at the moment. Even in this difficult time, I mean, we can leverage on other means of communication. We have Zoom protocols, we have WhatsApp, we have Skype. Unfortunately, it's a situation where absence can make the heart grow fonder.
Oh, you mentioned, Justin, that family law is one of the top concerns that your firm receives. So we've also read accounts of divorced people whose ex-spouses are using these safe distancing measures to limit access to their children beyond what's agreed in the custodial arrangement. So what's your advice in that situation?
That is squarely what new regulations are meant to address. We've got we've got the COVID-19 Temporary Measures Act and the subsidiary legislation there too. The regulations were passed on 7 April 2020, but that didn't address the specific issue of custody laws. So but it is now addressed in the new section 4.3. So essentially what it means is that if you are leaving your residence in order to transfer custody of a child, you should be allowed to. So nobody should be able to, a divorced spouse should not be able to hide behind the COVID-19 situation and say, I can't transfer custody over to you. In line with that, the family justice courts have made it possible to make certain urgent applications to enforce access rights. So you have, I think that is the best route that can be taken at the moment. But before we even get to a litigious posture, perhaps some communication, some consensus and agreement can be reached between the spouse. We are already facing pressures of economic, social nature. Can we arrive at a decision which is in the best interest of the child?
Justin, having said all that, do you think then there's too much grey area in these circuit breaker measures? Would it be more, say, prudent to enforce a tighter lockdown, except for essential services, of course, like what other countries have done?
I think it would be difficult and slightly irresponsible of me to critique the present measures. What I can say is that as a lawyer, looking at the laws which change every single day, I mean, our lawmakers are in an unenviable position. If there are new laws being passed, I think we should do our best to abide by them. We've really come to a situation where we have to do what we can with what we have where we are.
Right, fantastic ending words there, Justin. Thank you so much for your time and for explaining the new laws. We've been speaking to Justin Chan, Senior Partner and Head of Dispute Resolution Practice at Tito Isaac Co. To support the community during this pandemic, the team there set aside 1 hour every Wednesday from 5 to 6 p.m. to answer legal questions from the public. It's by appointment and you can register at titoisaaclaw.com.